session of March 27th. They're behind tab A. Any comments on the minutes?
Move to adopt.
Second? All in favor?
Aye.
Any opposed? Okay, the motion to adopt the minutes is carried. The next item of business is our executive director report. I've asked Ellen to give us a report and an update on several issues that have been ongoing, including the office plan, the timing of our consolidation and collapsing of our space, a hiring update, and these are the items that are ticked off on our agenda. So, Ellen?
Thank you. Morning, everyone.
Good morning.
So on the office plan, we are proceeding productively on the office plan, and that's on two parts. The first part is the consolidation of the space in Albany, and as I described, the proposed plan is to consolidate the third floor to the second floor, which will release that space and will allow for significant savings for JCOPE. We're on schedule for that. We have plans in place. We are working with OGS. We have delayed some of the actual moves so that it's later in May and probably early June, and that's in large part to ensure that we don't have any disruption in our server or computer processes during the filing season, which is the filing deadline for the FDSs, as you know, is May 15th, which is a nice segue to the update on that, which is we have the notices out and we are underway in the filing season, and the deadline for the FDSs is May 15th, as you know, and so far the systems are working. I should also mention, just going back to the office plan, that we are proceeding also with downstate and Western New York locations, and that is progressing nicely as well and as planned. On the hiring update, we continue to recruit actively. We've interviewed. We've had more than 30 interviews. We have some outstanding offers, which are pending background checks, so that's good news, but we still are recruiting heavily, and we are looking forward to filling those spots and getting staffed up. I should mention, it's a point that's probably somewhat obvious, but we do have some difficulty, given our budget, that our salaries are not as competitive, certainly not competitive with the private sector, but not even competitive in the public sector.
Why is that?
So that's an issue, because we have a very limited budget. So that is a challenge, but one that I think we will be able to overcome. I wanted to update the emergency adjudicatory regulations have been filed and are effective. So that's good news, and we are also proceeding, as we discussed, with the regular SAPA process on those adjudicatory regs, and I believe the public comment period on that expires sometime in July.
That's great. That's great.
You'll see also on tab B, we've included a proposed schedule for the commission meetings through December. We did that because there are some summer holidays and other holidays that required moving around meetings, and we thought that it would be a benefit to have the schedule predetermined and set for the next 6 months or so, and through December. We thought it would help for your scheduling purposes, and it certainly helps for our scheduling purposes. So I would ask that you take a moment and you look at those proposed dates, and that we try to finalize those dates as soon as possible.
Which one were the fixed day of the month, which is what we were doing? I mean, at least that I could understand and remember.
These are all Tuesdays. And what happened was the last Tuesday of the month, which is the fixed schedule previously and does make sense, because of some of the holidays coming up, it was hard to accommodate the last Tuesday of the month. And once we got off track on one, it moved another one back. And so what we've tried to do, because we have certain statutory deadlines and that we have to do things within 45 days and the like, we tried to come up with a schedule that made sense, that was still on Tuesdays. We tried to keep towards the end of the month on a Tuesday, but we also tried to accommodate the various holidays over the summer.
Under 30 days seems to make more sense to me than some of these are 35 and 36. That would create greater problems than if we shortened the period as opposed to lengthening it.
These are all
I'm
open to
looking at a
discussion.
45-day and just by counting, I'm concerned about some of these gaps.
We've proposed these schedules to take into account the days. So these are all, we think, well within our deadlines. And once we have the days set, we will work around it and make sure that the work is teed up accordingly. So that's not a concern, but it's certainly open for discussion to accommodate everyone's schedules or for other reasons.
Well, I, for one, am delighted with the August 7th, September 18th date, because I desperately need a vacation. And this latter part of August is a great time for everybody to go. The courts are down. And then there's Labor Day, and then there's Jewish holidays, so it kind of makes sense. So,
We're trying to accommodate.
Yeah, no,
some
that's
of those
great.
issues.
And I also thank you for not picking one of the dates on my birthday, because that would have been really intolerable.
I tried to
There
get
goes the self.
specifically put in for your birthday.
Oh,
We have to decide who's going to bake the cake.
oh.
You may, excuse me, you may want to note, I believe, that that September 18th date may be the second day of the Jewish New Year.
18th September?
I believe so.
I can call my rabbi, he'll tell me.
Is there a problem with that date?
Yep.
Okay.
Yeah.
Okay.
Yeah, it is.
That's the benefit of
We'll change it,
paper
and
over.
you know what we'll do? We'll circulate an email with the dates.
That's fine.
Okay. Anything else under the director report?
That's it.
Okay, any questions for Ellen regarding any of the topics?
Yeah, just one question. On the public comment period, when approximately does that expire in July?
In,
July 10th.
July 10th? Okay. And I think it's just a great idea that we've got public comment on our records.
well, that's a SAPRA process.
Yeah, wonderful. Thank you.
Anything else? Okay, moving to item number 4, confidentiality and record access committee report. Our committee has met. The committee is composed of Commissioners Levine, Batra, Rath, and myself. We have proposed, I believe there's a recommendation that's going to be reported out regarding meeting guidelines and as to how to proceed with the records access policy and procedures regarding whether to implement those by regulation or rule. And Commissioner Levine, would you please report on the work and the recommendation?
Thank you, Judge. The impetus, of course, of the committee's activities was to craft a comprehensive and I will also say comprehensible policy with respect to public access to records and our deliberations. And a chestnut that has already been roasted to a fare-thee well is this tension between the statutory exemption we have from the open meetings protocols, but also the statute's grant of prerogative to the commission to maximize the ambit of what is in the public domain. And the committee has tried to strike that appropriate balance. And we had terrific support from the staff. They've done an outstanding job. The issues are somewhat intricate and nuanced, and my compliments to the staff, and they were very patient with at least one commissioner. So I'll let Ellen walk us through the proposal.
Okay. And I thank the committee as well for their work and diligence with this. As Commissioner Levine just mentioned, the effort here is to strike the right balance. As you know, our statute, Executive Law, Section 9419B, provides that all meetings or proceedings are not public unless expressly provided otherwise by the Commission. And as you also know, that means generally the open meetings law does not apply. However, there is a very real and diligent effort to have whatever can be conducted publicly and with the greatest transparency possible. And that's what we endeavor to do with these guidelines. So I'll just highlight some of the seminal portions, which is if you skip through the definitions, paragraph 3 says as follows. The Commission shall endeavor to ensure that matters that can be addressed publicly are addressed in a public proceeding, and generally, unless doing so would be inconsistent with law, it then sets forth the following types of matters that should be open to the public and that will be conducted in the public, and that's as follows. Proceedings relating to proposed guidelines and policies, proceedings relating to rulemaking and the promulgating of regulations, proceedings involving administrative matters of the Commission, and discussions or proceedings involving reports on agency statistics or performance-related data, including any reports involving the Commission's publicly available data. In addition, any hearing to determine whether a civil penalty should be assessed for a violation will also be conducted publicly. Of course, those hearings are conducted by the hearing officer and not by the Commission. And then finally, any matter which is consistent with law and Section 5 below, which I will get to, that would be open to the public pursuant to Article 7 of the Public Officers Law, which is the Open Meetings Law. And there are, of course, other provisions in that section that talk about making the public proceedings accessible to the public and accessible to the press, again, in an effort to make it as transparent as possible. Section 5, which is referenced in that part, is the section that references the proceedings that will be held in executive session. And it provides that on a majority vote of the Commission, certain actions will be conducted in executive session for the following purposes. That's for any matter relating to specific investigations, enforcements, or adjudication, pursuant to the confidentiality restrictions of Executive Law, Section 94, which obviously is the statute governing JCOB, including deliberations regarding a hearing officer's recommendations or finding. However, it does provide that Commission votes regarding a hearing officer's recommendations or findings, or the Commission's votes regarding a proposed settlement, will be recorded and will be made public upon the issuance of the final order of the Commission. In addition, matters appealed to the Commission pursuant to guidelines, regulation, policy, or statute where a vote by the Commission constitutes a final agency action, such as an appeal from the Executive Director's denial to delete or exempt certain information from financial disclosure, and matters involving proposed, pending, or ongoing litigation, personnel matters, or matters involving private information, discussions relating to the sale or lease of real property, and any other matter enumerated in Public Officers Law, Section 105, which is again referencing the areas in the Open Meetings Law that the Open Meetings Law dictates should be held in executive session. There are other details here, but those are the seminal provisions of these guidelines. Any comment?
So I do have a comment, and I continue the question that we raised in the committee. First of all, I think this is absolutely fabulous that JCOB is striking out in support of making things as public as possible. I come from the belief that structural matters should be public, and operational matters, particularly dealing with the core of investigations and the like, must be kept confidential. And I think the Department of Buildings having architectural plans on file, but they don't have on file what color the walls are painted, or how people are living in that particular structure. The basic one area that I want additional consideration from the commission is that everything that occurs in the commission is by majority vote. And if you look at 5.1a and possibly 5.1c, the only issue that comes up is that the commission votes regarding a hearing officer's recommendations, finding, or votes regarding a proposed settlement will be recorded and made public, which is appropriate. What is not mentioned there is when a non-majority action occurs as permitted by the law, which is when a veto vote is done. So what you have is a minority vote by veto overriding the majority, and I still continue to believe that that should be made public. So I would just ask that 5.1a, which is something we discussed during the committee as well, that the veto vote should be made public. And that's just that's my recommendation.
Well, can I just ask a question on that?
Sure.
If you're voting on a final decision, on a recommendation by a hearing officer, 5.1a looks to me like it says that the dissenting votes will be recorded, so
That's correct.
can you explain
The
how?
difference here is when you're voting on a determination of a hearing officer, that's after there has been a public hearing. The matter is public, and then the commission's vote on whether to ratify, approve, adopt, amend, reject that hearing officer's recommendation is then recorded and is made public as part of the final order of the commission. The distinction with what Commissioner Batra is raising is in matters, investigative matters, which are subject to the confidentiality restrictions of 94, those matters are not public, and there's no and they are confidential as part of the investigation, and so there's no mechanism to make them public.
Do we have a mechanism, though, under that set of facts on the threshold question of whether an investigation should go forward? Is there communication with third parties, though, if the commission decides not to go forward with an investigation, either to the
There is
target?
confidential communication to the subject, and in some instances, confidential communication to the complainant.
So if an agency referred a matter to us and there was a legislative veto, then that would be disclosed in a letter to the subject of the complaint and to the referring agency.
That is correct.
And they, of course, are then free to publicize whatever it is that they'd like to publicize about the letter they get. Am I right about that?
That is accurate.
So there would be a path, that would be a path for a disclosure, although indirect, for the legislative veto. I think, is that right?
I would assume the other agency is subject to our rules as far as confidentiality
That
is
assumption
concerned.
seems fair.
I mean, why could you go out the back door what you can't do at the front?
I don't know, I mean, that's why I'm asking, I don't know.
The non-disclosure is pursuant to statutory prohibitions, so why would they be any more free to make this public disclosure than we?
I don't know, the prohibition, what is the legislative underpinning for our prohibition? Is
It's
it unique?
section, it's Executive Order 94.
Okay.
If we could just go to 94, I think 94 9A sub B is the section that we,
That's a different section. 94 9A sub B is when there are instances when confidential communications can be communicated to third parties.
indeed, I was just going to compliment, because I had a different read of this back in December when I looked at this, and I saw 9A sub B, the last sentence, being the Scooter Libby, clause. But thanks to you, Ellen, that I now understand that to be a Herbert Teitelbaum clause. So, and I think it matters because that particular last sentence is referencing that a confidential communication occur. For example, if there's an investigation and the commission authorizes you, Ellen, to have a conversation with another agency, that is the ambit of that particular sentence. It's not an open valve that we can make anything non-confidential that was confidential.
I think Commissioner Horowitz is referencing specifically, though, not that provision, but 94, Section 13B, which speaks to if the commission determines at any stage that there is no violation or that or any potential conflict of interest has been rectified, it shall advise the individual and the complainant, if any. But all of the foregoing proceedings shall be confidential.
Right, no, I understand. I mean, we had this conversation that whether it's in an annual report or an interim report, because we're not limited to an annual report, we can do it whenever we want, that there is that way of
Well, I'm not sure.
documenting.
I don't see there the agency, the referring agency listed as someone that we just referred to. Is that in another
It's a
section?
complainant. It talks
Well,
about
the agency's
complainant
not a complainant.
in some instances.
A question, if a complainant is an outside party and a veto vote is exercised, what information does the complainant receive?
The complainant would receive, in certain instances, if the commission is not proceeding on a matter, the complainant would receive information that the commission is not proceeding on a matter.
And no information about how it arrived at that
That is correct.
decision?
Ellen, could you just cite me to 9413A? Towards the bottom of that subsection, there's a references to the various vetoes, be they legislative, executive, or otherwise. Given that you have 13A and then you've got our ability in the rest of 13, which is to issue a report and say which matters we did not go forward with, how do we kind of comport the two?
I'm not entirely sure that I understand the question, but all of the proceedings in 13 are confidential. That's what the statute provides. The statute does provide giving certain notice to individuals who are relevant parties in the investigation. It doesn't make those matters public. It just authorizes the disclosure to those interested parties. Is that the question?
Yes. Indeed. Good.
So is there a motion on the table with respect to the proposed meeting guidelines,
I would, Judge.
as written and contained in the book?
Yes.
Is there a second?
A second.
All in favor?
Aye.
Any opposed? Okay, the motion is carried. Now, with respect...
Your Honor, before we exit this subject, though, may I suggest that the committee continue in existence to monitor our practice and experience with this and to recommend changes that we may deem appropriate to the full commission.
Excellent suggestion. Regarding the regulation, Gary, do you want Ellen to talk about the recommendation regarding whether to proceed with the records access policy by way of regulation or rule?
Yes.
Thank you. As you know, the commission previously voted to adopt certain policies and procedures for records access. They were on the website, and they are the policies that we are following. There was subsequent discussion raised by the commission and then continued discussion at the committee level as to whether or not those policies we should pursue promulgating them as regulations. And it is the recommendation of the committee that we promulgate those policies as regulations. And so that is what we're putting before the full commission today, is that we take the policies and procedures that have already been ratified by the commission, and that we pursue the SAP process, both as emergency regulations, which can be filed relatively expeditiously, and then also pursue the full SAPA process.
Okay. Any questions regarding that?
Do we want to have a discussion on the guidelines, the blue boxes that are in our
Well, we're not
attachment?
there yet. We'll get there.
The spilled coffee must, yeah,
You're rushing.
the,
Okay. Is there a motion on the table to promulgate the policy and the procedures? Oh, I'm sorry. George.
No motion.
Oh, motion.
I'll make the
Okay, thank you.
Second.
All in favor?
Aye.
Any opposed? Motion is carried. Now to the lobbying guidelines, okay? So our staff have worked hard to prepare guidelines. Sherry has done an extraordinary amount of work, and we really need her to pull in her approach, and we appreciate that, Sherry. And I'll let her talk to you about how we use our guidelines, some of the new issues that have arisen. I assume everyone's had an opportunity to review them. And Sherry, why don't you start, and then we'll open up the discussion for some time.
Okay, thank you. The lobbying guidelines historically have been, or have served as the frequently asked questions, where we provide guidance and assistance to those lobbyists and clients who are actually filing the reports. It provides clarification and explanation on various requirements in the statute. So first and foremost, these guidelines reflect the recent amendments to the Lobbying Act enacted by Chapter 391 of the laws of 2011. And so we're asking you to approve these guidelines today so that we can post them on the website. And they will then be current and reflect the recent statutory changes. I'd like to walk you through some of the most substantial amendments. On page 12 of the guidelines, the statutory definition of widely attended event was modified to include criteria for what constitutes such an event, and the supporting guidance was subsequently modified to make clear that complimentary attendance does not include travel reimbursement or payment for travel or lodging. Also, on pages 27 and 28 and 30 and 31, there is explanation and clarification on the Commission's late fee program. The Commission is authorized to pay late fees on any report that is filed late. And there's been some. What we tried to do is provide guidance to help people calculate the deadlines for this. And the amendment also, the guidelines also includes the late fee schedule as part of the guidelines. And we also note that the executive director has authority to issue discretionary waivers in very limited circumstances, and the guidelines require that persons may apply for such a waiver on an approved form with a link to the form, which is located on our website. Other matters of clarification and best practices include page 11 adds definitions of bona fide charitable and political event. Page 14 adds definitions of professional and educational programs. Page 13 clarifies that a registration fee is not required when filing a registration amendment. It's a question that we receive a lot. And there's also a provision for when a lobbyist or client is estimating what lobbying costs are, guidelines for how they could establish that when it's an estimation. And lastly, we've also included some information on lobbyist disbursement of public monies reports, which was a new requirement added actually in 2007, and the guidelines have never reflected some of those guidance, and now they do. And I'm happy to answer questions if you have specific specific questions on any of the blue boxes, if you will. And
Commissioner Butler?
Thank you, Madam Chair. I want to go kind of out of order. If you could look at page 12, under 2I, Buck said, complimentary attendance does not include travel reimbursement or payment for travel or accommodations. Now, I've had a personal experience back in the early 80s when President Reagan presided over the country. I remember having called his liaison person on the issue of prayer in the public school, and the White House asked for travel to be paid by the sponsoring charity. So I'm just wondering, why are we eliminating the attendance to not include travel reimbursement?
The statutory exception is complimentary attendance at an event. And the guidance is just to give clarity and stay within the spirit of the law, which is complimentary attendance. It doesn't mean other related expenses. So it's trying to be, it should be limited, and the guidance is making it clear that it is limited.
Well, I mean, I'm just saying I have a problem with this because I think that there are, you can't get higher than the White House, and they asked for complimentary travel to come to an event because they have their own budgets and they don't want to spend it. Everybody's dealing with limited budgets, like you were earlier saying that we're not even meeting the public salary ranges. I mean, which is bothersome. But so I would think that this should be complimentary attendance should include travel reimbursement and accommodation.
This, remember, is statutory language. These are the provisions that are saying what is not going to be considered a gift, right? So these should be narrow exceptions, and the guidance is consistent with that.
I just wanted to add, I don't want to get off track, but there's also Part 930, which is a regulation that is in effect. We're not discussing that today. And that does set forth limited circumstances where a public official may accept travel.
Ah, okay. And what are those exceptions?
It's, without getting, it's a complicated
Forward that to him if you don't.
I will.
Yeah.
It's a complicated regulation, and I could forward it to you.
So I have a question. Sherry, regarding reportable business relationships and source funding and regulations relating to those two. Let's talk that issue through.
Go ahead, Ellen.
Well, on those, we don't have, those are two new significant amendments, as you know, as part of the law, and we've discussed them briefly. And because they're new, we have not included guidance in these proposed guidelines that we would like to post. And the recommendation that we would ask the Commission to consider is that we pursue a mechanism to solicit public comment on those two new amendments so that the proposed guidelines and regulations for those amendments can be informed by the public comment.
So how would, are there any suggestions as to how we go about soliciting public comment? Would it be by conducting public hearings? Would it be by soliciting written comment?
I think the two most viable mechanisms would be public hearing, and there is some precedent for that. The obvious advantage there would be an opportunity not only to hear the public comment, but to also question and engage the participants in a very public way. And I think another mechanism would be simply to solicit written comment that could then be considered and presented to the Commission for its review. I think those are probably the two most viable mechanisms.
Any thoughts?
Or both. Or both. The hearing is preceded by written comments, and then the Commission would determine who would want to at a hearing.
Submit your written.
We want to hear
The
from you,
committee
we'll let
reviews
you
it.
know.
I agree with
Be
Mark.
able to hear from everyone.
I agree with Mark.
That's
I
a
think
fairly
it's an
standard
excellent idea.
protocol, yeah.
I agree with Mark.
Yeah. Okay, great. Any further discussion on that?
Kind of an
What-
agreeable.
Very agreeable.
Okay, getting back to the proposed guidelines, then, is there a motion to adopt the guidelines as written? Thank you, is there a second?
I'll second.
All in favor?
Aye.
Aye. Any opposed? Motion's carried. We need a, yeah. So, do I have a motion that we proceed with respect to the formulation of the regulations on reportable business relationship and source funding by conducting a public hearing?
Second.
All in favor?
Aye.
Any opposed? Okay. Motion's carried, and what we'll do is we'll put together a format for that, and we're working on that right now. I think that's excellent. Okay. New or other business? Anyone? Okay, there being no new or other business, do I have a motion?
I was just going to make one comment. I am most grateful to your colleague, Madam Chair, the DA of Suffolk County. Quite an interesting read, and I think almost a Bible for what we need to do. And the grand jurors who sat in that grand jury who issued the report. So hats off to them.
Thank you. Noted in the record. Okay, so do I have a motion to enter into executive session pursuant to Executive Law 94-9B? We have investigative matters to discuss.
So moved.
Second? All in favor?
Aye.
Any opposed? Okay, we are adjourning into Okay, we're back in the public and open session of today's meeting. Let's go right to Roman numeral number 8, public action, announcement of actions from executive session. Today there is no reportable action to be reported out. Roman numeral number 9, the motion to adjourn
Yay.
the public meeting.
Yay.
Is there one? Judge Covello, second.
Second.
All in favor?
Aye.
Opposed? We are adjourned, and we will email out the date of the next meeting. Thank you.